to the online lecture. Myself Nitin Kumar, partner Vidhira, legal consultant in law coaching. Topic for today's discussion is stages of a civil suit. Before we proceed with the stages of a civil suit, I'll give you an overview of the Code of Civil Procedure, and then we'll move specific with the stages of a civil suit. I want to give you the outline of the entire lecture which I will be delivering today. First, I will be discussing the very nature of the CPC, the procedural law, where I will distinguish between the substantive and the procedural law. Then, what is the history of the code? Then, the third point, the scheme of the code, how the code look like, what are the unique features of the CPC, then what are the essentials of a civil suit, and the last, the main topic for today's discussion, that is the stages of a civil suit, which is broadly classified into 4 different phases, which you can see from the board: pre-institution phase, trial phase, and the judgment phase. Now let us begin with the first topic, subtopic for today's discussion: substantive law and the procedural law. Now all of us know the entire set of law is broadly classified into 2 parts. The first part being the substantive law and the second the procedural law. Now all of us know what do we mean by the term substantive, but let me define. Substantive law confers powers, determines rights, duties and the liabilities of the party, whereas procedural law prescribes the procedure or machinery to enforce those rights and the liabilities which are created by the substantive law. And often we believe that the procedural law is subservient to substantive law. Is it so? Whether, now the question before us, which we have the general notion that procedural law is subservient, means we put it on a lower pedestal than the substantive law. I particularly believe, and I will prove, that substantive law and procedural law are complementary to each other. Without an efficient substantive procedural law, we cannot have an efficient procedural substantive law. Procedural law is considered subservient, but the efficacy of substantive law to a larger extent depends upon the quality of the procedural law. Unless the procedural law is simple, expeditious and inexpensive, substantive law, how good it might be, will not be able to achieve the desired purpose, that is the justice. Let me explain this with the help of an example. Consider the Indian scientists have created an indigenous satellite which has a malfunction. Indigenous satellite which has a multifunction and first of its kind in the world. Now you require that particular satellite to put it in the orbit. Now for putting the satellite in the orbit, it requires the rocket launcher. Now here consider rocket launcher as a procedural law and the satellite, which is very effective and one of its kind in the world, as a substantive law. How good might be the satellite? You will not be able to achieve the desired objective and the purpose until unless the rocket launcher is so effective to put that satellite in the orbit. Satellite will start function and give the desired result only it reaches the orbit. But for that you need an efficient rocket launcher, without which it is meaningless. Therefore, without an effective procedural law, that substantive law is meaningless. Therefore, substantive law and the procedural law both goes hand in hand. Both are complementary to each other and one is not subservient to the other. Now, coming to the second topic, history of the code. Generally, all of us have the notion that procedural law is difficult than the substantive law. Let me confess and let me assure that it is very easy and I will make it easy for you throughout my lecture series. How it is very simple and very entertaining. Now, let me explain you the scheme of the code. The code of civil procedure. Now, whether this is the first uniform code? No. The first uniform civil code was enacted in the year 1859, and then there are various other code, and then we come with the present code 1908. Why the 1908 code was enacted? To achieve few objectives, to give more flexibility and to meet the local needs of the various governments. For that we have to understand what is the scheme of the code. Code here means the code of civil procedure. The CPC is broadly divided, classified into two parts. The first part, which is known as the body of the code, and the second is the rule. Body of the code consists of 158 sections in 11 parts, whereas the rule consists of 51 order in the first schedule. And along with that, there are 6 appendixes to it. Now, as I have said, the unique feature of the code, where the first part, that is the body of the code, which contains 158 sections in 11 parts, is the substantive part of the CPC. Is the substantive part of the CPC, whereas the rule, which contains 51 orders in the first schedule, is the procedural part of the CPC. So here, that is the unique feature of CPC, both the substantive part as well as the procedural part. Now the former, the substantive part, which lay down the general principles and create jurisdiction, while the later contains the provision relating to the procedure and also indicate the mode in which the jurisdiction which is created by the body of a code has to be exercised. Now what is the unique feature? The body of a code can be amended and is fundamental, can be amended only by the legislatures. Can be amended only by the legislatures. Here I have not specified either the union legislature or the state legislature, because this is in concurrent list. This is in concurrent list. So body of the code, being the substantive part, can be amended only by the respective legislature, and which is fundamental and cannot be amended by anyone else. Whereas the procedural part, that is the rule containing 51 orders in the first schedule, can be amended by the high courts as well. In addition to the legislature, it can be amended by the high courts as well. Now why such power is granted to the high court? To attain the flexibility, they are in the better position to understand and know the local needs depending upon their geographical locations and many other factors. So such power has been conferred and bestowed on the high court to meet that local needs, that they can make changes in the procedural part. But now the question may arise, as we have to read both the part, the body of the code and the rules together. If there is any inconsistency, then which will prevail? Obviously, if there is any inconsistency, the court will try, who is the final interpreter of the law, to try to reconcile and to do an harmonious construction of the same. But if that is not possible, then the former will prevail over the latter, means the substantive part will prevail over the procedural part of CPC. I believe there is no doubt about the same. There is no doubt. In my slides, which I will be providing the same, which gives you all the relevant provision, which empowers the High Court to make the respective amendment and the certain limitations on the power of the High Court while exercising that power in amending the procedural part of CPC. Now coming to the next subtopic, what are the essentials of a suit? Now we are proceeding to our main topic for today's discussion, that is stages of a civil suit. Before we proceed with the stages of a civil suit, now the stages, you know, what are the stages, different phases, a civil suit. Now before we proceed with the stages, let me ask what is a civil suit, and for that we have to know what are the essentials of a civil suit. Essential means without which we cannot say. What are the essentials of a civil suit? Can we have any dispute with ourselves? Therefore, there are generally 4 essentials of a civil suit. The first essential being there must be opposing parties, or there must minimum 2 parties. There must be minimum 2 parties. Second, there must be a certain subject matter in a dispute. Third, there must be a cause of action. And the last, the relief claim. So these are the 4 essentials of a civil suit. Opposing parties, second, subject matter in dispute, third, cause of action, and the fourth, the relief claim. Let me now explain all these four terminology in brief. Opposing party, as I said, there must be two parties. So they are the two parties who disagree on a particular point of law or a point of fact. Hence, they approach the honorable court for a resolution of the same, and whatever been said by the court is binding on both the parties, and they have that particular dispute in a particular subject matter, in a particular. Hence, the second is subject matter dispute. कि किस context में तुम्हें problem है, grievance है, dispute है. So there must be a party and there is a dispute in certain subject matter. जिस context में होगा, that is a dispute. Third, there is a cause of action. Cause of action is all set of facts, a bundle of facts which needs to be proved to achieve the desired relief. For example, if I as a student of my university, if I feel aggrieved by any action of my professor, तो मुझे पता है that I am aggrieved by such an action of the professor and what relief I am expecting. So I will appropriate the appropriate authority, might be the director of the institute, might be the dean of the institute. Now there is a dispute between me as a student and the professor. So there are two parties. Second, their dispute is with regard to a subject matter. It might be with regard to the delivery of lecture, with regard to the content what he is providing, whatever it may be. So the second essential subject matter. There is a cause of action. What is the triggering point? So what are the facts which resulted into this dispute? So that is a cause of action. And the last, what relief I am expecting. Hence, so once you are approaching the competent authority, the dean of the institute, you are expecting certain relief. Whether or not you will be able to get that relief is in another question. But are you expecting certain relief? Answer is yes. Hence, you are approaching the competent authority that he will give his decision on the same, which both of us will abide by the same. Hence, the four essential being the opposing parties or the disputing parties, subject matter, third the cause of action, and the last the relief claimed. So these are the essentials. Now by understanding the essentials of a civil suit, I'll quickly proceed with the stage of a civil suit. If you understand the stages of a civil suit, half of your CPC is done. Trust me. Now I expect you to understand the stages in a very layman. Don't consider you as a law student. How the trial proceeds or the civil suit proceeds from the date of the institution, from the first date till the last date. Here I will be discussing how once you feel that you are aggrieved, you need a redressal from a court of law. So you should know what is the mechanism. For example, if I say that I have a right of life and liberty, if my right and life and personal liberty is being infringed, there must be some mechanism to enforce those rights, and if there is no effective mechanism, then that is useless simply by determining that right. Hence, we should know what is the process to get a remedy or to get it enforced. Hence, this becomes very important to know what is the process. And this is the process how you think as a logical, as a reasonable, prudent man. The same way it proceeds, but you have to think without being biased. So now, for that purpose, I have divided it into four broad phases. First is the pre-institution phase. Second, institution, trial, and the judgment. Before I proceed with the intricacies of each stage, let me give you a brief overview of each stage. Pre-institution phase. Here, the term is pre-institution. The institution, actually you put the civil law into motion. Means you are approaching the competent court, having the jurisdiction to try that particular suit. So before instituting the suit, by way of presentation of prayer, you are going for a pre-institution, which is generally a conversation, a discussion between the client and the attorney, his counsel, who suggest, who guide whether what course of action should be taken or is an appropriate course of action in such a dispute. So therefore it is a pre-institution and it is a very important stage. And then we actually put civil law into motion by instituting a suit by way of a presentation of a plea. Then it ends with framing of the suit. So the institution begins with presentation of a plan and ends with framing of the issues. Then we start with the trial, the actual trial. Then after the arguments are settled and the court reserves the judgment, that ends the trial, and then the court actually pronounces the judgment, and then the last execution. So final disposal of the suit in the apex court. Okay. Now let us proceed one by one with each stages. Now the pre-institution, as I said, this is the most and very important stage of a civil suit. Now let me explain pre-institution. What are the points which I have mentioned under the pre-institution? Determine the claim and relief, research law, evaluate the evidence, the ADR mechanism, time, privacy, and the possibility of enjoying the fruits of the judgment, the statute of limitation, and the legal formality. Quickly, let me explain you what is the determine the claim and the relief. Now, if you recall, I have mentioned you the four essentials of a suit. That what is your claim, what is your claim or the cause of action, and what is the relief which you are expecting. If you are approaching a lawyer, you are not well versed with law. Even in India, it is expected that you know the law, but you don't know the intricacies and the complexities of law. So when you approach to a law, what we call as a client counseling or a client conference, you inform into that this is, if you go to a doctor or a lawyer, what is the first question? कि क्या दिक्कत है भाई और क्या चाहिए? What is the problem and what you expect from me? So what is the problem means what you are expecting, what is your claim in such a dispute. If you are one certain claim, therefore you have to approach the lawyer who will be representing you in a court of law, who will put forth your point before the court of law, and the relief will be granted by the court. He will try to understand and you will explain him what is the claim and what is the relief which you are expecting in this case. Now, this is the duty of the lawyer, as this is also one of the, lawyer should be a patient listener. I will try to understand and analyze what is the claim and what is your relief. For that, why that is necessary to be understand, with the help of researching the law, the knowledge of law, to understand that what is the cost benefit and analysis of the potential lawsuit. Then only I will be able to suggest and guide my client whether to proceed and what course of action, whether we should go to the regular court by instituting a suit or whether we should go for an ADR mechanism. So if you are expecting, for example, if there is a breach of a contract and you are asking for a compensation of 10,000 rupees, but for instituting a lawsuit and to pay all the court fees, the process fee, lawyers fees and every other thing, you are going to incur the expense of 50,000. Whether it is advisable to claim a compensation of 10,000 to bear a cost of 50,000? No, it is never advisable. So by this, the lawyer will do a cost benefit analysis on the potential lawsuit which you want to institute in the court of law. For that, he have to understand your claim, he will have to understand your relief which you are expecting with the help of the knowledge of the law which he have. After that, he have to measure, he have to see what are the chances of winning the case, and for that he have to evaluate the evidence, as the evidence is broadly of two kinds. One is oral and one is documentary. So who are the witnesses who is going to depose in your favor? कौन से witness है जो तुम्हारे favor में कहने वाले हैं? And what are the document you have to substantiate your claim? What are the document which you have? So evidence broadly of two types, oral and documentary. तो कौन से ऐसे oral और कौन से ऐसे documentary evidence हैं जो आपको claim को support कर रहे हैं and will help you to get your desired relief? So the question before the lawyer is whether you have sufficient evidence which will help the court, will assist the court in getting you the desired relief. By this, we will be actually measuring what are the chances of winning or losing the case. And after doing all these three things, we have actually came to a conclusion whether we should go ahead with the suit or whether we should go for an ADR mechanism. After that, we will guide taking into consideration the chances of winning and losing, the cost and benefit analysis, and the law which is involved in the case. I will suggest whether to go for an outside court settlement or whether to approach the court. As we know, the process in the court is rigid, complex, and there are certain rigidity which we cannot do away with. We are bound by it. So like now India is getting more momentum in the present era. There are various reasons for the same, why the people are opting for the same, mainly in the case of commercial dispute, whether they don't want. So if the party is very adamant and he want to proceed with the suit, I will inform that it is going to be time consuming, it is going to hamper your privacy, because everything will be in the public domain. And the last, what is the possibility of collecting the fruits of the judgment? A civil suit may go for 10 years, 15 years, 20 years, depending upon the nature of the suit. So I will inform that what might be the possible time which will be taken for getting the final judgment from the court of law. And then if he is very clear and certain that yes, I want to proceed with the suit, then actual work or the duty of the lawyer begins. He will take into consideration what is the statute of limitation, whether this suit is within the period of limitation or not, and then what are the legal formalities to be complied with. Once the suit is within the period of limitation, I will go for the legal formalities. Legal formalities are who will be the parties to the suit, in which jurisdiction suit will be instituted. अगर कोई चीज लखनऊ में हुआ है तो आप लखनऊ में कोर्ट को jurisdiction है. You cannot go and file a suit in Delhi or Bombay. So where, in which court the suit will be instituted? So who will be the parties to the suit? In which court the suit will be instituted? So parties, jurisdiction, and what is the claim and what is the relief, which already you have figured out. So these are the 4 things which needs to be complied with, which needs to be figured out for the purpose of framing the suit. For the purpose of framing the suit, that we call as a legal formality. And once the suit is been framed, you will proceed with the next. And you put the civil law into motion by actually presenting the plate. Now, as I have said that there are 2 disputing parties, opposing parties, which we call in CPC in the civil suit as plaintiff and the defendant. Now the plaintiff, the document of the plaintiff, where he have put briefly all his claim, is known as a plaint. P-L-A-I-N-T, plaint. Now the plaint has been drafted where it has been mentioned who are the parties, what is the jurisdiction, what is the claim, and what is the relief. And he institute the suit by way of a presentation of a plaint. Once the plaint is presented in a court of law, the law will, the presiding judge, the court will apply the judicial mind, whether there is a prima facie case is made out or not, whether he have paid the court fees, he have complied with all the process or not. And once the court is satisfied, court will admit the plaint. And once the court admits the same, the suit is actually instituted. And once the suit is instituted, it is to be informed to the other party that a claim is raised against you, and he will be given an adequate opportunity to file the reply to it. So after presentation, a summon will be issued. Summon is a notice of the court intimating the other party and giving him the time and specifying the date on which the court expect the other party to file the written statement. So written statement is the document of the defendant, the opposing party. And after that, if you feel, you can also give the additional pleadings, which is replication in the rejoinder. Replication is again by the plaintiff and rejoinder by the defendant. Now, while issuing the summon, in the summon the court specify a particular date where the court expect both the parties to appear in person or through agent of the pleader. Now the date which is specified for both the parties to appear before the court of law, that is called as the date of first hearing. That is called the date of first hearing. Now what is the object of the first hearing? The object of the first hearing is to frame the issues. Now what is the object of the first hearing is to frame the issues. Now, as this is a legal word, what you literally means the term framing of issues. The court will actually try to find out what is the actual dispute between both the parties. Dispute means one party is asserting something and other party is disagreeing to it or denying the same. कि क्या actual dispute है, and the court will pass a judgment on that dispute only. Hence, on the date of the first hearing, with the objective of framing the issues, there are certain tools in the hand of the court and the parties for the purpose of effective framing of the issues, to actually find out what is the real and the actual dispute in the. For that purpose, the court has the power of examining the parties, discovery and inspection where the court feel. Therefore, at the first hearing, court actually go through the pleadings of the party. What are the pleading? The plain and the written statement which is already submitted by the court. After going into the same, if the court is not able to figure out or to frame the issues, court may examine the tools in the hand. Court may discover the facts or discover the documents, and for the same inspect. The court may ask for certain admission. Then court may ask for production of certain document which the court feel need to be produced but it not been produced. So these are the tools in the hand of the court as well as the party. Discovery, inspection, admission, the production. After which the court will actually frame the issues. And if the court feel that this is such a matter where it can be resolved through ADR, court can refer it at this particular stage for resolving it through ADR mechanism. Now, once the issues are framed, the issues are settled, that this is the actual dispute between the two parties, the institution comes to an end. So, framing of issues, settling of issues is the last thing in the institution phase. And once the issues are settled, the trial begins. And once the issues are settled, both the parties are supposed to file the list of witnesses within 15 days of the framing of issues. Within 15 days of framing the issues. Now, as I have said, the evidence are broadly of two types: oral evidence and documentary evidence. Oral evidence are the witnesses who is going to depose in the court of law, and documentary evidence already which we have produced along with the plaint and the written statement. Respective party have produced all the documents which they rely upon for the purpose of a claim in the defense along with their pleadings. So now both the evidence is on record before the court of law, either might be oral evidence or the documentary evidence. Now there is an opening statement, and who have a right to begin? Right to begin is always with the plaintiff. Right to begin is always with the plaintiff in the civil suit and prosecution in the criminal case. So, opening of a case by the plaintiff. Then plaintiff will adduce all the evidence in support of his claim. Then all the document which you have produced. Now you have produced certain document in support of your claim as a plaintiff. You will produce the document. If the court find it to be relevant, court will admit that document, and court will mark it exhibit. Marking of exhibit means court will number it down, and the other document in the court feel it to be irrelevant, court will return those documents, will reject those documents. So this is the process of finding out all the document which is produced to be marked with a statement regions, that is called exhibiting of the document. After all the oral and documentary evidence is on record before the court of law, the other party have a right to cross-examine. Right to cross-examine the witnesses of the plaintiff. The cross-examination by the defendant of the plaintiff witnesses. Now, why cross-examination is a matter of right and is very important to test the veracity. Now, you may waive your right of cross-examination, but the court is under a duty and the compulsion to give you an opportunity to cross-examine, which is a mandate as per law, without which no weightage can be attached to such evidence which is adduced by the party. So it is for the purpose of testing the veracity of the evidence and to what extent what weightage can be attached. The same process will also be followed for the purpose of defendant. Defendant will produce all the evidence, it will be on record, it will be marked exhibit, and then the cross-examination of defendant witness by the plaintiff. Now once it has been done, then once the evidence and everything is closed, is on record, then starts the oral argument. And once the oral argument means now all the evidences are there on record, now the counsel for each of the party will argue in the court of law that why this evidence to be taken into consideration and should be the basis of a judgment. Why this evidence should be taken into consideration and should be the basis of the judgment, and why the evidence of the other party should be discarded. So now, according to section 136 of the Indian Evidence Act, this is the sole discretion of the court that what weightage has to be attached to each evidence produced by the either party. And so you have to satisfy the court that what weightage has to be attached to the and what should be the basis. But all evidences whether of the plaintiff or defendant has to need to be appreciated by the court. Need to be appreciated. Whether you are accepting either a sole or a ground need to be appreciated. So once the final argument, now after the amendment, you are also expected and required to submit the written argument before the court of law, which will come on record. Once the argument is closed, that is called the conclusion of the trial or the final hearing, the court posts it for judgment. Now, once the trial is concluded, the court is under compulsion to pass a judgment within 30 days, to pronounce the judgment within 30 days, or the court can extend it till 60 days, stating the reasons for the same. So in all circumstances, the court is under duty bound to pass a judgment within 60 days from the conclusion of the trial. And once the judgment is pronounced, the court is under compulsion to draw a decree within 15 days. Now, once the judgment is passed and a decree is drawn, what are the possible options? Now there can be three possible options. Either plaintiff is satisfied, first defendant is satisfied, third plaintiff is partly satisfied and defendant is partly satisfied. Means, so what are the recourse? Try to remember, there is always a remedy, there is always a recourse to it. So if you feel as either as a plaintiff or defendant agree by the decision of the court, you have an option of appeal. You can go for an appeal or you can file and review. Appeal is always before the superior authority, appellate authority. So you can go for an appeal. And if the appeal is not allowed, you can go for a revision. Review is by the same court. You are filing an application in the same court for the reconsidering certain defect or error which is apparent on the face of it. So once the judgment is passed, but there is certain timeline which has been provided. You can file an appeal in the same court, district court within 30 days, in the high court within 90 days, review within 30 days, and then revision also. Revision under CPC is only with the high court, and that is for 90 days. And after that, you can go for an execution of a decree. Execution of a decree means when there are two parties, the judgment debtor and the decree holder, who is entitled to the fruits of the judgment. And if the judgment debtor, the other party, does not satisfy the decree, you will file an application into the court of law for enforcing the judgment, to actually enjoy the fruits of the judgment. And by this, we end the entire civil trial and it comes to an end. I believe you have no doubt. In my subsequent lectures, I will be explaining each of the points in more detail with a tabular form to explain you the same. Thank you very much and all the best.